Social Justice Civil Rights Boot Camp. My name is Michael Bergman, and I'll be the moderator for our first program of the day. Our panel for the first program is Retaliation, the civil rights issue of our time. I serve as Executive Director of the Public Interest Law Initiative, or PILI, based in Chicago, which is a statewide not-for-profit that connects lawyers and law students with public interest law and pro bono opportunities. It's a pleasure to be with our panel today and serve as your moderator. Retaliation is a growing civil rights issue in labor and employment law. Employees who speak out against discrimination, harassment, or unlawful workplace practices often face severe consequences. Retaliation not only undermines workplace equity, but also disproportionately impacts marginalized communities, creating further barriers to opportunity and justice. Our distinguished panelists will provide insight into legal protections for employees facing retaliation, the broader systemic issues at play, and strategies for pushing much-needed reform. We'll explore recent cases, discuss advocacy strategies, and examine the role of statutory protections in combating workplace retaliation. During today's program, we encourage you to ask questions of our panelists through the Q&A, not the chat function. If you do not see the controls, please ensure your screen is not idle. We'll be monitoring the Q&A, and we'll do our best to address your questions, time permitting. We will share a recording of this program with everyone who has registered, so please share it widely within your networks. Now, let's meet our esteemed panelists. Professor Wendy Green is a leading scholar and advocate in anti-discrimination law, particularly regarding race, color, and gender equity in the workplace. She's a tenured professor at Drexel University's Thomas R. Klein School of Law and director of its Center for Law, Policy, and Social Action. Professor Green has pioneered two groundbreaking legal constructs, misperception discrimination and grooming codes discrimination, which have shaped key legal decisions, policy reforms, and civil rights legislation in the US and abroad, including the passage of Crown Acts nationwide. She is a sought-after expert, public speaker, and legal consultant on issues of civil rights and workplace equity. Professor Dacre Steele is one of the country's foremost experts on anti-retaliation and whistleblower law. She teaches at the University of Alabama School of Law and has published extensively in top law reviews on the adequacy of legal protections for individuals who report discrimination, labor violations, fraud, and regulatory breaches. Her background includes serving as a civil rights attorney for the U.S. Department of Education and working for the U.S. Department of Labor. She has also held numerous leadership positions within the ABA and other legal organizations dedicated to civil rights and employment law, and was my co-coordinator in putting together this year's boot camp. Attorney Christopher Keyes is a partner at Quinteros, Pietro, Wood, and Boyer, PA, and was recently elevated to co-chair of the firm's Business Risk Division. He has served as a chief ethics and compliance officer and led the enterprise-wide compliance initiatives. His expertise in regulatory compliance matters and corporate ethics investigations makes him an invaluable voice in understanding retaliation from a governance and risk management perspective. Again, thank you all for being with us today. We'll start with a question broadly for all panelists. Why do you believe retaliation has become such a critical civil rights issue today, particularly in the workplace? Attorney Keyes, we'll begin with you.
And thank you, Michael. I personally believe that retaliation has become a critical civil rights issue because of the deleterious effects that it brings on the workplace. If you think about civil rights, they guarantee equal treatment for all citizens under the law. Likewise, they represent fundamental fairness. And so if retaliation is allowed to metastasize, it can truly undermine trust and negate the proper enforcement of laws and regulations.
Professor Green.
I agree. And okay, and good morning to everybody too, and happy Friday with Christopher. And that is such a central part of our civil rights apparatus in order to be able to really fully exercise and enjoy our civil rights, to be free from various forms of discrimination. It's important that if individuals are trying to oppose discriminatory practices or participate in the investigations or any kind of processes or proceedings related to discrimination, that they be free from retaliation when they're exercising their civil rights. Without that, I don't know if we could really have fully effective civil rights protections without anti-retaliation protections. Unfortunately, it's one of those parts of the civil rights apparatus that oftentimes gets overlooked, but it is truly critically important. And I would oftentimes say or think about just generally speaking, how kind of intuitive, unfortunately, it is for employers and other people to retaliate against individuals when they are exercising their rights. So it's such a very common phenomenon. Regretfully, obviously, but in terms of our anti-retaliation protections, it's really critical to be able to address this very commonplace form of discrimination and loss of working opportunities and economic security that comes as a result of those.
Thank you. Professor Steele.
Good morning. So of course I agree with both Attorney Keyes and Professor Green. Our civil rights laws that are on the books, and it doesn't matter what area it's in, it can be in voting rights, it can be in housing, it can be in labor and employment, which will be the crux of what we'll talk about at this panel. But these laws were in many cases hard fought for, and it took a lot to get the law on the books at in the first place. Our default rule in the United States is at will employment. You can be terminated absent a contract to the contrary for a good reason, a bad reason, or no reason at all. And so that's the default from which Congress operates. And Congress will only get involved and pass a law, whether it be an occupational safety law, a wage theft law, anti-discrimination law. They'll only get involved and pass a law if they feel that that law is absolutely necessary. And when you have people who are seeking to exercise their rights under these laws, who are either being retaliated against or fear being retaliated against, then basically it has the effect of negating the law in the first place. And so retaliation is something that can make the laws on the books with respect to rights of employees, with respect to rights of others generally, null and void. And that's one of the reasons it's such a critical civil rights issue and something that civil rights lawyers need to be very diligent about addressing.
Thank you all for that. Professor Green, let's return to you for a moment. In your experience, what challenges do marginalized employees face when trying to assert their rights against workplace discrimination and retaliation?
Well, I think, really workers generally, and even more specifically, marginalized employees really are suffering challenges as it relates to the lack of clear as well as affecting reporting mechanisms within their workplaces, especially if the person to whom you report discrimination or retaliation is the perpetrator of that conduct. We also see a lack of access and information about how to file charges of discrimination or retaliation, whether it's within your organization, with the Equal Employment Opportunity Commission, or any other kind of state, federal, or local administrative agency. When workers have been able to file or successfully file charges and legal complaints and initiate federal litigation, which is mostly what my work is about, there are significant procedural hurdles as well as substantive evidentiary hurdles that have been created by federal courts when they have been interpreting our civil rights protections, and that workers have to overcome. And one of the major things that my work and my experience has been able to illuminate is that federal jurisprudence, as it relates to our civil rights protections against discrimination and retaliation, are generally pro-employer, right? And so they protect, unfortunately, in a lot of instances, employers more than they protect the workers who might be experiencing this discrimination and retaliation. And this federal jurisprudence oftentimes doesn't really reflect the lived realities of discrimination and retaliation. There's like this disconnect between what's really happening on the ground and how federal judges are addressing discrimination and retaliation. And so as a result, our anti-discrimination laws, anti-retaliation laws, the ways in which you can effectively redress these forms of inequality do not always effectively prevent or redress or deter discrimination and retaliation. And so so what I've seen through my scholarship and my advocacy is how federal jurisprudence oftentimes preserves workplace discrimination and retaliation in contravention to the purpose, the spirit, intent, and even plain language of our civil rights statutes. And so in light of these kinds of challenges, you can see that it is really hard sometimes and oftentimes for workers to bring viable claims of discrimination and retaliation. And these real challenges that are being created, whether organizationally or through jurisprudence, really are things that we have to address through legislation, more legislation and enforcement guidance and other types of reforms within our organizations as well, so that workers, whether they are marginalized workers or just workers more generally, do not have to any longer confront these types of infringements upon their civil rights, as well as infringements upon their civil rights when they're trying to assert them in courts as well as in enforcement agencies.
Thank you for that. And Professor Steele, your research focuses extensively on retaliation and whistleblower protections. Could you walk us through the existing legal frameworks that protect employees who report workplace misconduct?
Sure. So currently we use a burden shifting test with respect to cases alleging retaliation in a labor and employment context and in many other contexts as well. That starts with the establishment by the alleged victim of retaliation of a prima facie case. So in order to kick off the framework, in order to kick off the legal analytical framework, there must be protected activity. That individual must, the plaintiff or the complainant, if it's at the administrative level, must have engaged in protected activity of which the employer was aware. And that can occur in different ways. Probably the most common way is to file some sort of complaint. You file a complaint of discrimination. You file a complaint of wage theft. You file a complaint of a violation of an occupational safety and hazard rule. That reporting or filing of a complaint, or in some cases filing of a charge with an administrative agency like the EEOC, is going to be considered the protected activity. And so the plaintiff will have to prove that they engaged in protected activity of which the employer was aware. That's very important because if the employer did not know that you filed the complaint, then the employer terminating you 2 weeks later would not have been because you filed a complaint, because the employer did not know about it. So must engage in protected activity of which the employer is aware. There must be some sort of adverse action. And most people use a narrower scope of what constitutes an adverse action than should be used. We know the easy ones. If you were fired, if you were not hired, if you were demoted, if there is a failure to promote, those are examples of adverse actions, but there are other examples as well. Being transferred, in some cases, transferred to a different location, in some cases transferred to a different team or group, or even having your work hours change. In some cases, having your workspace change. So you used to work in this office and now we're going to put you in the dark basement. So there are lots of different types of adverse action. We used to call them adverse employment actions. And if you go back to old cases, you'll see the term adverse employment actions. But now we recognize, and the SCOTUS has recognized, that the adverse action does not necessarily have to be employment based. If I go outside and slash your tires, that has nothing to do with your personnel file, it's still considered an adverse action. And so there must be some sort of adverse action and a causal connection. So causation becomes important, a causal connection between the adverse action and the protected activity in which the plaintiff engaged. If the plaintiff can establish that prima facie case, you got your protected activity of which the employer was aware, there was an adverse action and a causal connection between the protected activity and the adverse action. If the plaintiff can establish those four things, then the burden actually shifts to the employer to prove a legitimate, not prove, because it is not a burden of proof, it's a burden of production, to produce a legitimate non-retaliatory reason. If the employer can do that, the burden then shifts back over to the plaintiff, and the plaintiff has an opportunity to show that the reason espoused by the employer is actually a pretext for retaliation. And there are three primary ways to show pretext. One is there's no basis in fact. I didn't fire you because you filed the harassment complaint. I fired you because you were late to work, but you actually were not late to work. And the video surveillance cameras at the employer can show it. And the time you went in with your key card can show it. There's no basis in fact. The reason espoused just simply is not true. Another way to show pretext is that the adverse action was not warranted by the conduct. You've been working here 27 years, perfect record, no discipline, no employee discipline or anything like that. You were 2 minutes late to work the day after you filed a complaint, or the day after you served as a witness in somebody else's complaint, and all of a sudden you got fired. Well, the termination was, or the 2 minutes being late, 2 minute tardiness was not sufficient to warrant what actually occurred, not sufficient to warrant a termination in that situation. And the third primary way to show pretext is that it actually did not motivate the conduct. What the employer is saying was the reason actually did not motivate the conduct. Well, you said you fired me because I'm 2 minutes late, but I have a list of people who were 20 minutes late, 2 hours late, and they still have their jobs. What's the difference between me and them? I filed some complaint. I engaged in some sort of protected activity. And if the plaintiff is able to prove that the spouse reason is pretext, then and only then can the plaintiff prevail.
Thank you for walking us through that. Attorney Keys, let's turn to you again. From a corporate governance perspective, what role do compliance programs play in preventing workplace retaliation?
Mike, I read a quote years ago that resonated with me, and I'm going to paraphrase it a bit, but it essentially said that compliance professionals need to be omniscient and omnipresent. Daunting task, right? Cue up the Mission Impossible theme song. But fundamentally, well-designed compliance programs inspire the right behaviors. I think well-implemented and effective compliance programs encourage a speak-up culture where employees know, managers know, leaders know that employees have not only an affirmative obligation to raise concerns, but are encouraged to raise concerns without fear of retribution. And so in my mind, compliance programs do play a critical role in preventing workplace retaliation. And I see compliance programs as the connective tissue among several things that companies need to be aware of at all times. Legal responsibilities, compliance, regulatory compliance obligations, the company's stated core values, and the affirmative policies that discuss the company's commitment to treat employees fairly, and of course, any code of ethics that the organization may have.
Sorry that I couldn't get that Mission Impossible music there for you, but we'll work on that for next year's boot camp. Professor Green, in light of your work, again, as I described in your bio at introduction on grooming codes, discrimination, and misperception discrimination, as well as your work on the passage of the Crown Acts, along with recent executive orders on DEI that we're now seeing come to light in the last few months, what do you see, or where do you see some of the most significant gaps in this area?
Well, I think Attorney Keys pointed out a really significant gap in terms of employers really cultivating a culture for people to be supported in asserting their rights, opposing discriminatory conduct and being supported in that, or unfair conduct and being supported in that. So we have the right, but oftentimes it's not translated when we are in our workplaces effectively. So that's one gap. And I would also say that, again, federal jurisprudence plays a really critical role in also incentivizing and encouraging workers to either speak up use their voices to challenge discriminatory conduct or not do so, right? So in my scholarship and my advocacy on grooming codes discrimination and misperception discrimination, what you really see are a lot of gaps in federal civil rights protections that federal courts have created through very restrictive statutory interpretation. And in doing so, that federal jurisprudence maintains both discrimination and retaliation in contemporary workplaces. So for example, if an employer, so my work alongside with respect to misperception discrimination demonstrates that, for example, if an employer misperceives a worker as Muslim and discriminates against the worker based upon this misperception, numerous federal courts have held that the employee does not have standing to bring a religious discrimination claim under Title VII. And so what they're saying here is that you only have, or you're only going to be afforded statutory protection against discrimination on the basis of the worker's actual identity or their actual religious identity. So accordingly, the worker cannot bring a viable discrimination claim even though animated by an employer's incorrect classification or perception of their religious identity. So another way of thinking about that is that even though you're animated by a religion or you're motivated by religion and engaging in that discrimination, the employer may not have a viable claim of religious discrimination under Title VII. And obviously you can see the gap in civil rights protections against religious discrimination and other forms of discrimination under this imposition of what I've called an actuality requirement in these cases. And so this very narrow interpretation of Title VII substantive protections against discrimination can negatively affect workers' abilities to bring retaliation claims under Title VII. So for example, if the worker opposed what I've coined as misperception discrimination, or what is also known as perceived as discrimination under Title VII, because he reasonably and understandably believes that this kind of discrimination violates Title VII's prohibitions against religious discrimination, he may not have an actionable claim of retaliation. And this is again in light of the narrow interpretations of Title VII substantive protections against discrimination in these misperception or perceived as discrimination cases. And so ultimately, some federal courts in this retaliation context would not perceive opposing misperception discrimination or perceived as discrimination as a protected activity. Right. And therefore, you would not have protection against retaliation under Title VII. I would also want to note that some federal courts have ruled in the opposite direction, to be clear. So I did want to just point that out, but you have a split amongst the federal courts as it relates to this issue. And what is also important to note is that these cases, whether you are affording statutory protection to perceived as or misperception discrimination under Title VII or not, that these Title VII misperception discrimination cases could shed some light on how federal courts may decide Title VII or other civil rights cases brought by federal as well as private employees who are challenging discriminatory or retaliatory terminations, demotions, change terms or conditions of employment of workers who held positions advancing diversity, equity, inclusion, belonging, and access in their workplaces. Or it could actually shed light on these kinds of adverse actions for those individuals who may have supported such initiatives. And so these negative employment decisions could be reasonably argued as being animated or motivated by the consideration of protected classifications like race, sex, national origin, color, sexual orientation, gender identity, age, religion, veterans status, disability, and so on. And potentially, in light of these cases, we may see some federal courts saying that you have an actionable claim of discrimination or retaliation. Other courts may say that you don't have an actionable claim of discrimination or retaliation, depending on how they're looking at it and whether or not this Title VII case or your ability to bring a Title VII case is conditioned upon the worker's identity classification. Or another way of thinking about it, it it'll be really determinative as to whether or not federal courts in these Title VII cases will claim that in order to bring a claim, it has to be discrimination on the basis of your actual identity or your actual identity characteristic, or they might have a much broader approach and then advance that you can bring a claim simply because these kinds of negative employment decisions are motivated by protected classifications under our federal civil rights laws. So I just use that as an example of kind of the gaps that are being created by federal courts and how they can inform the decision making in these cases. I'm sure just a slew of cases that are going to be brought by federal and private employees who have been adversely affected either due to their jobs as officers of diversity, equity, inclusion, or those who are supporting those types of initiatives.
You on mute, Michael?
Michael.
I asked that entire question on mute. I know. I was just testing to see if you're all paying attention. Professor Steele. Are there any particular high-profile retaliation cases from recent years that you believe highlight systemic failures in protecting workers?
I do. And what's so interesting is for half a century, from 1960 to 2013, we had very robust anti-retaliation laws, very robust interpretation of anti-retaliation protections. And so when in doubt, what the court would do is they would interpret the question before them, interpret the law before them in a way that provided for the broadest protection against retaliation possible. The court said there's a case from 1960, Roberts v. DeMario jury. It was a Fair Labor Standards Act case. 1960, that's before we had the Civil Rights Act. That's before we had a lot of the legislation that's on the books today. But in it, the court basically says, look, we understand that for the regulatory system that Congress set up to be effective, we need to have a way to protect people from retaliation, because we understand that if people are fearful of losing their jobs, then they may turn a blind eye towards things that are either illegal or substandard or things of or exploitative, things of that nature. And so literally for half a century, we had these broad interpretations of anti-retaliation protections. Enter the year 2013. 2013, we have a case, University of Texas Southwestern Medical Center v. Nassar, and it was a Title VII case. It had a discrimination component. It also had a retaliation component. And in that case, what the court did, it was a 5-4 decision, but in that case, what the court did was it changed the causation standard for Title VII retaliation cases. Now, Title VII was amended in 1991, created in 1964, but amended in 1991 by the Civil Rights Act of 1991. And since the amendment, all of the circuits had been using the same motivating factor or causation standard. There was no circuit split in this particular instance. The court ends up taking this case, the SCOTUS ends up granting cert on this case, and what it did was it split the causation standard. So for instance, in a Title VII discrimination case, Title VII discrimination case, the causation standard that you're looking for is a motivating factor standard. Did your race, color, religion, national origin, et cetera, did one of the protected classes under Title VII motivate the employer to take this adverse action against you, motivate the employer to take this action against you? Maybe it wasn't hiring you, maybe it was firing you, whatever the case may be. And so we have a motivating factor standard there. But in Nassar, what the court did was it said, well, we know in this section of Title VII, it talks about a motivating factor, but because that was not then repeated in the section that talks about retaliation, we're going to create a dichotomy. And so you have a motivating factor causation standard in your Title VII discrimination cases. But even though it's under the same statute, if it's a Title VII retaliation cases, we're going to apply a but-for causation standard, which is a higher level of causation. Causation is the number one reason why people who have actually been retaliated against cannot prove their retaliation cases. And so what the court did at a 5-4 opinion is to make it more difficult. And changed a standard whereby there was no circuit split, but changed the standard to but for causation. And one of the most disturbing things about that case, it was an opinion written by Justice Kennedy. And what he said in it was one of the primary reasons he felt that but for causation was warranted had nothing to do, I shouldn't say had nothing to do. There was also a plain language argument. Court says anytime you use the word because, if you use the word because out on the street, what you mean is but for causation. So there was this plain language argument, but more so than that, there was a floodgates argument. At this point, we have more retaliation cases filed with the EEOC than we do discrimination cases. And it's been like that for well over a decade. And so the court says, oh, well, we're getting so many cases that we need to make it harder for the plaintiffs to prove them because we're having so many cases. Now, that said, if you are getting lots of people who are filing retaliation cases and the EEOC tracks merit resolutions, many of the retaliation cases that are filed are meritorious. There are more meritorious retaliation cases filed than there are discrimination cases in other areas. But that was the case that kind of started this downward spiral, kind of started or kickstarted the court not giving the same level of protection to retaliation, not giving the same level of robust interpretation to retaliation statutes or retaliation clauses and statutes that it used to. So that is probably the primary case as far as making retaliation protections more anemic, watering them down. We also had a case that came out in 2020. It was Comcast v. the National Association of African American Owned Media. Some of you all may be familiar. This is a Byron Allen case. That was actually a Section 1981 case. And what the court did there is the same thing they did in Nassar. Nassar was a Title VII case, but in 2020, the court says we're going to apply but for causation to Section 1981 claims as well. You have Digital Realty Trust v. Summers. That was a Dodd-Frank case. What's so interesting is protected activity is what's going to kick off any retaliation case, any whistleblower case. You have to have engaged in some sort of protected activity. And what the court did in Digital Realty Trust is it said that with respect to this particular statute, your protected activity must be reporting to the EEOC. If you go and you report someplace else, you report to your boss, you report to your HR department, you report to another federal agency, then that is not going to be sufficient. You will not have the protections of the anti-retaliation statute. You won't have any whistleblower protections because you did not specifically report to the SEC. Now, to be fair to the court there, a lot of that had to do with the way the statute was drafted. I do think Congress needs to do a much better job with the drafting of these statutes. We're coming up on the 100-year anniversary of anti-retaliation clauses in statutes. 1926 was the very first one in the Railway Labor Act of 1926. And so coming up on 100 years, still having trouble getting that language right. So can't blame it all on the court. But when the court said, no, you must report to the SEC, what it did was it narrowed what does and does not constitute protected activity. And even though that case only dealt with one statute, we have other courts, lower courts, that are applying that more broadly. And then there's a case that I don't think was wrongly decided. It's Burlington Northern Santa Fe Railroad v. White. I do not think it was wrongly decided. I think it's being incorrectly applied. What that case gave us was the standard for what constitutes an adverse action. If something may have well dissuaded a worker from filing the charge. If I knew that I was going to have my work session changed, if I filed this charge, I might not have filed it. If it may have well dissuaded someone from filing the charge, then it is considered a materially adverse action. The issue is with respect to the lower courts, they are starting to misapply that, and things that absolutely should be considered adverse actions, like putting false reports in performance evaluations that will ultimately end up to with the person getting fired because they'll have so many negative consecutive performance evaluations. But lying on performance evaluations because the person has filed some sort of complaint or participated as a witness in some sort of investigation, that for many courts will not be considered adverse action. And so again, I don't think there's anything wrong with Burlington Northern, the case. I think we're having issues with respect to how the lower courts are applying it.
Thank you for that, Professor Steele. And we've had a request, if you're able to drop any of those cases into the chat, or if you've got a summary and can later add them to the resources, that would be great. People were interested in following through with what you were saying there.
Sure, I will add them to the resources, have staff add them to the resources afterwards.
Perfect. Thank you for that. And for the panelists, we do have some questions coming in the Q&A while another panelist is speaking. If there's any that you're able to type a response to, that's great. Otherwise, we'll pull some of them out as we go, keeping an eye on time and just wanting to make sure we cover all that you have prepared for today. And with that, we'll turn to you, Attorney Keyes, again. What advice would you give to attorneys advising clients who fear retaliation from reporting workplace misconduct?
So, Michael, I actually, pardon me, contacted a colleague and friend and expert in the labor and employment arena to essentially pressure test some thinking that I had on this particular question. And I'm glad I did, because we collaborated on a few points that I'd recommend to the audience. So if attorneys have clients navigating a potential retaliatory situation, we'd recommend, or I would recommend, that you counsel your clients to, number one, familiarize themselves with the organization's anti-retaliation statements. They likely exist in a code of ethics, in HR policies, et cetera. And also recommend that those clients begin their discussions reciting that verbiage. I know that the company says it does not permit retaliation based upon the content of page 5 of the code. So that's one. The second, base all allegations on facts, not on conclusions or supposition or emotion, which is difficult. But in other words, say, the company has reported $9 billion in sales, but the information that I have suggests the accurate number is $7 billion. To the contrary, having a generalization or conveying a generalization like the company is defrauding people in its sales numbers is much more amorphous and more difficult for the organization to investigate. Number 3, maintain a dispassionate stance. Again, to the extent possible. Please don't make yourself a crusader or a martyr, but instead someone who wants to do right by the organization, right by the shareholders, and protect the company's interests as well. Number 4, and this is probably one of the more critical ones, do not abscond with documents. Identify where the location is, the repository is, the system is, but don't take them home, particularly if they're not publicly available information. And finally, track any management behaviors that change before raising the concern compared to afterward. And that includes everything that my esteemed colleagues have mentioned. The frequency of check-ins, the frequency of performance write-ups, the sudden strictness in terms of requiring that the employee adhere to attendance guidelines. So all of those areas could potentially constitute indicia of retribution that a client, a potential client, should record. Back to you, Mike.
Thank you for that. Professor Green, we'll come back to you. Are there any innovative strategies you've seen work, particularly in regards to grassroots advocacy, that has successfully led to stronger protections for employees facing retaliation?
Sure. So I've had the opportunity and the great privilege to consult and present advocacy and legal scholarship to a diverse set of employers, from multinational companies and firms to boutique or small employers, on a variety of civil rights matters. And one of those matters is grooming codes discrimination, which is the discrimination, as I see it, discrimination and inequality that results from the implementation of workplace grooming policies. And like policies or practices that prohibit African descendant workers, for example, from wearing natural hairstyles like afros, braids, twists, locks, bantu knots, among others. Over the past 5 years or so, I've seen a definite increase in employers' voluntary adoption of workplace policies that are actually affirming workers' rights to express their identities rather than prohibiting workers from wearing hairstyles, hair coverings, and dress that may be related to their cultural, religious, or racial or even gender identities. These shifts in grooming policies have largely come to fruition due to grassroots advocacy or the advocacy of workers, as well as workers who are becoming aware of legislation like the Crown Act, the Creating a Respectful and Open World for Natural Hair Act, becoming more aware of employers' obligations, statutory obligations to accommodate religious observances and preferences, and also more awareness around accommodation and respecting and affirming individuals' expressions of their gender identity and sexual orientation, among other identity characteristics. And you've also seen them become more aware of relevant enforcement guidance, whether it be on state and local as well as federal levels, as well as other legal and policy reforms governing grooming codes discrimination, or what is also known as appearance or aesthetic discrimination. So I've definitely seen a seismic shift from punitive or what I would consider to be hyper-regulatory grooming policies and practices, a shift from those to affirmational or affirming policies governing hairstyles, hair coverings, and dress that that really afford organizational protection against discrimination on those grounds. And by extension, these organizational policies implicitly, I would argue, protect workers from retaliation if they are engaged in protected activity like opposing discrimination, appearance discrimination, or grooming codes discrimination. This kind of protected activity concerning the violation of these workplace policies. So, for example, if a worker was harassed by a coworker for wearing a natural hairstyle and filed a complaint regarding this harassment or opposed it in some other manner, such workplace policies affirming the worker's human right to express her cultural or racial or religious identity would naturally afford protection against retaliation when the worker opposes a co-worker's infringement upon their right or their interference with the exercise of this right that's being actualized by this organizational policy. So sometimes, I will say that maybe organizations might not really be aware of the fact that, yes, as they are trying to promote non-discrimination on the basis of certain expressions of identity, that at the same time, they are promoting non-retaliation or anti-retaliation when workers are actually exercising these rights that the organization is affording through their workplace policies. And all of these things are happening for a variety of reasons in terms of greater levels of awareness. But I will have to say many of these policies are not necessarily mandated by law, but rather they are being incentivized and the result of really clear grassroots advocacy on the behalf of workers. And also, I would say a part of that advocacy is also about education and training as it relates to these forms of discrimination that oftentimes employers may not be aware of until the workers are actually really illuminating the ways in which workplace policies like grooming codes are really an engagement in discrimination and need to be addressed.
Thank you for that, Professor Green. And back to you, Professor Steele. What legal or policy reforms do you believe are necessary to strengthen anti-retaliation procedures?
I could spend all day on that question, but I'm gonna give you some of the biggies, some of the highlights. One, I believe we need to make sure that our laws encompass something that's come to be known as anticipatory retaliation. What is anticipatory retaliation? employee gets in some sort of accident, has nothing to do with the job, not a workers' comp issue, just randomly gets in a car accident, because of that, develops some type of disability as a result of the accident. Employer finds out about the accident. Now the employee has not returned to work yet. Employer finds out about the accident and decides to fire the employee before the employee can do something like request a reasonable accommodation. Well, the first step in any retaliation case is engaging in protected activity. That employee would not have engaged in any protected activity because they got fired before they could request a reasonable accommodation, which would be protected activity. And so because of that, there are many circuits that say that employee will not be allowed to recover. One interesting thing, we have all these wellness programs now, all of these employers collecting biometric data about employees. It is not uncommon for an employer to know that an employee is pregnant before the employee knows that the employee is pregnant. And so because of that, it may be that the employer goes ahead, fires the employee, doesn't want to have to deal with time off, parental leave or FMLA or anything like that. So let me go ahead and fire this employee. And the employee has no idea that it was because the employee was pregnant, because at the time of the firing, the employee may not have known that the employee was pregnant. Those are examples of anticipatory retaliation, and those are in many circuits not actionable. And we need to have Congress, we need to have Congress legislate and the courts interpret in a way that would make those types of anticipatory retaliation cases viable for the victims of that type of retaliation. You also have, as Professor Green mentioned just a moment ago, interference. So you have retaliation over here, and then there's like a first cousin over here called interference. And what interference does, or interference clauses do, is they make it illegal for an employer to interfere with the exercise of your right under a particular statute. And so it may be that I told you, if you file a uh, national origin harassment complaint, I'm going to fire you. And so you don't file a national origin harassment complaint, even though you're experiencing national origin harassment. You never filed the complaint, meaning you haven't engaged in protected activity. So you're not protected. But if the statute had an interference clause, as some statutes do, uh, then you telling me, you threatening to fire me if I filed the complaint, that alone would be actionable, because you have interfered with my rights under, in that case, in that particular hypo, under Title VII. And so I believe that interference clauses need to be read into every statute. Every workplace law statute should be interpreted as having an interference clause, and that's not new, because we have the courts have read into statutes retaliation clauses where they were not explicitly there. We've done that with Section 1981. We've done that more recently. I say more recently, it was 2005, but we've done that with Title IX. Title IX technically does not have an anti-retaliation provision, but we've read it in. And so I think we need to do the same with respect to interference clauses. And then causation. Again, causation is the number one reason why people who've been retaliated against cannot recover for retaliation. And I believe we need to go to a contributing factor standard. If you reporting wage theft contributed to you being fired, you being demoted, you not getting the same number of hours that you used to get, then that should be actionable. You should not have to have but for causation, which granted is not sole cause, right? There is a difference. But you should not have to prove but for causation if you can prove that your filing of the complaint contributed to your adverse action. And so I'm going to just stop there with those three, but lots of legal and policy reforms that need to come down the line. In essence, we need to, my very first law review article is titled Protecting Protected Activity. We need to protect protected activity. We don't need to water down what constitutes protected activity. And we need to make sure adverse actions are actually viewed that way. And so you don't have situations like, I'm going to falsify your next 3 performance appraisals, and then after 3, I will be within my right to go ahead and fire you.
And again, Professor Steele, you've had lots of interest in the chat and in the Q&A about a lot of the cases you ran through. Professor Steele has offered to put that into the resources after the session. So for those of you inquiring about some of those specifics, we'll make sure that that gets into the resources for today's programs. One of the questions we had in the chat, and I'll just open this up to whomever feels able to answer it. Can you speak to retaliation towards workers who want to unionize?
I'll take that one. So we have the National Labor Relations Act of 1935, limited in its scope with respect to who is covered under the act. But if you are eligible to unionize, then it absolutely applies to you. And so that has an interference clause in it. If an employer tries to interfere with your rights, your Section 7 rights, as we call them, because it's Section 7 of the act. But if your employer tries to interfere with your right to unionize, regardless of whether that interference is successful, right? Your employer might try to not get you to unionize and it be unsuccessful, you unionize anyway. But if they try to violate a Section 7 right or interfere with your right to unionize or to engage in any type of concerted activity, this law does not apply only to unionized companies or unionized workers. It may be that you are just engaging in concerted activity outside of a union setting, but falls under the act. So there's an interference clause there. You cannot do that. Doing so would be considered a violation of the National Labor Relations Act. I happen to think the NLRA has more robust protections than some of the other statutes. And so we have lots going on with respect to unions. Additionally, if you have a union already, so there's a collective bargaining agreement already in place, while your collective bargaining agreement cannot give you fewer rights. In other words, you can't contract away some of your anti-retaliation, anti-interference rights under the NLRA. It can give you more rights. And so the contract itself, the collective bargaining agreement, may also be a source of additional anti-retaliation, anti-interference rights.
Thank you for that, Professor Steele. Attorney Keyes, let's go back to you. As someone with extensive experience in risk management, what are some of the challenges that businesses are facing in ensuring whistleblower protections are effectively enforced?
And in the interest of time, I will be brief, but I think businesses face three primary challenges in this regard, and they are cultural, financial, and structural. So when I think about cultural challenges, they focus on the four dimensions of organizational justice. Do employees believe that they have fair outcomes, distributive justice? Do they believe there are fair processes in place, procedural justice? Do they believe that their interpersonal relationships with coworkers and or leaders are sound? Interpersonal justice. And finally, informational justice. Do employees receive communications from the company that is, again, fair and comprehensive? With respect to financial challenges, it comes down to budgets. Have organizations invested in training their investigators to know about trauma-informed interviewing techniques? Has the organization budgeted sufficient funds to create creative as opposed to rote training for training curricula for employees at all levels? And then finally, are the communication strategies engaging, or are they more simplistic? And I think one recommendation I have for organizations is to sanitize results of actual incidents that the company has investigated, particularly claims of retaliation. And if someone was exited from the organization because the organization determined after investigating that that person committed retaliation, I recommend highlighting the facts, not necessarily to identify or fingerprint the individuals, but those stories add to the culture of fairness that organizations pursue. Then finally, structural. Budgets are one thing, resources are another. And I do think that not just the quantity of individuals in the compliance functions, but also the quality. What are their areas of expertise? Is there an IT person? Is there a communications expert? Do you have someone who is skilled at investigating, who can help the organization promote efficient organizations? Where is the compliance function housed? Is it truly independent, or does it report to other components of the business that may have that may have a few objectives that are in tension with the compliance function. But fundamentally, building all of these facets into the risk assessment process brings us back to the risk management angle of retaliation. It's a sobering process, but I do recommend that the companies challenge their leadership teams about the existence or presence of retaliation at any point and at any level. Thanks, Mike.
Thank you for that. We're coming close to the end, so I want to give an opportunity for our panelists to do kind of a final thoughts. I know we've got a couple things happening in chat and Q&A that you've had your eyes on, so to the extent there's a way to weave any answers in quickly to your final thoughts, that would be great. Dr. Steele, we'll start with you. Then we'll go to Professor Green, then Attorney Keyes for the close.
Sure. So as far as final thoughts, I think it's very important for civil rights lawyers to be diligent about looking for retaliation claims. Retaliation claims and the underlying substantive claim are two different things. And the retaliation claim is just going to naturally come later after the person has engaged in protected activity. And so it's important to look at that, to understand that that is a separate thing. It's to understand that you need to counsel your client on what to look out for there, because they might not think the fact that they've always, for the past 7 years worked the morning shift and now they're working the graveyard shift after filing, they might not think that that is retaliation. So also letting them know and explaining in very clear terms that you're looking for differences before and after having engaged in that protected activity. Another thing I want to note is that I am going to drop the links for Professor Green's SSRN page and for my SSRN page in the chat. And so if you all are interested in scholarship in this area, you can go to the SSRN page, click on, read the summary, click on the law review articles that you are interested in, and they will be right there at your fingertips.
Professor Green.
Well, thanks, Professor Steele, for doing that. I appreciate it. And I'll just also put another plug out there for legal scholarship, that it does matter. And it matters in so many ways for either new practitioners, seasoned practitioners, and for workers. I can attest on behalf of Professor Steele and myself in the ways in which, and honestly, so many legal scholars, the ways in which I think accessible and action-oriented legal scholarship has really activated change amongst workers and other individuals as it relates to really trying to advance their civil rights, whether it be civil rights against discrimination, and or retaliation, and that workers are really driving forces behind educational efforts that provide new insights and awareness about workers' lived experiences with discrimination and retaliation. And oftentimes this kind of education that is being advanced by workers and oftentimes informed even by legal scholarship really helps employers to better understand the experiences of discrimination and retaliation that are affecting employees' well-being. It's affecting the workplace culture, productivity, loss of talent, and giftedness in our workplaces, and really helping employers or managers to better attend or prevent and redress discrimination and retaliation and resulting inequality. So I think it's really critically important to think about how these insights that are being shared by workers and also being informed by legal scholarship are shaping decision-making, organizational decision-making, which in turn generates new policies and practices that guarantee greater organizational protections against discrimination, greater organizational protections against retaliation, and greater protections against workplace inequality that even our state or federal law may not provide. And so I say all that to say is that workers have a really important role in actually advancing greater levels of protection against discrimination and retaliation than what even sometimes our federal, state, or local laws even require or even are envisioning.
And Attorney Keyes.
So I am incredibly grateful to have been asked to join the panel with these two esteemed professors. And I could listen to you both talk about your subject matter expertise for hours, but we have literally a minute left. And so I'm going to do one thing, and that's commend the audience to read two cases from the Supreme Court in 2024. Muldrow v. City of St. Louis and Murray v. UBS Securities LLC. What you will find is that this Roberts Supreme Court held in Muldrow that a job transfer can constitute an adverse employment action under Title VII. You'll also find in Murray that the text of the statute is what convinced the court that a contributing factor standard should apply to SOX-related whistleblower concerns and retaliation claims. And so everything that the professor shared are spot on, absolutely correct. And it's imperative that we understand both the content of the underlying statutes, naturally, but also how the courts are interpreting those statutes for evidentiary purposes. Thank you all for joining.
Excellent closing, Counselor. Thank you all so much for your preparation, for your thought, and for this thought-provoking discussion today. It's clear that retaliation is a pressing civil rights issue that demands our attention, not only in individual cases, but in systemic reforms that promote workplace equity. Our panelists have given us invaluable insights into the legal landscape, practical strategies for advocacy, and the urgent need for stronger protections. I'd like to extend my sincere gratitude to Professor Steele and Green and Attorney Keyes for sharing their expertise with all of us today. And thanks to you, and thank you to the ABA section of Civil Rights and Social Justice for hosting this important conversation. To our audience, let's continue this work, whether in our legal practices, through advocacy efforts, or in policymaking. Together, we can push for workplaces that protect and empower those who speak out against injustice. Thanks to our audience for joining us today for this free session. We'd like to express our gratitude to this esteemed group of panelists again. You are all doing such important work, and we thank you for taking the time out of your schedule to share your experiences. The section of Civil Rights and Social Justice provides free webinars and resources for professionals and advocates nationwide. We hope this helps you in your work. And again, if you can, please consider joining and becoming active in the ABA. You may do so at americanbar.org/CRSJ. We'll take a short break, but please don't go too far away. We hope you will stay and join us for our next panel, Building Successful Partnerships to Advance Your Cause, which will start at 12:15 Eastern Time and is accessible from the event lobby. Thank you all again. Have a great day and a great weekend.